Do you have anything you'd like to say? Madam Secretary, please call the roll.
Senator Alvarado, Senator Harper Angel, Senator McDaniel, Senator McGarvey, Senator Nemus, Senator Schroeder, Senator Southworth, Senator Storm, Senator Thayer, Senator Wheeler, Representative Bentley, Representative Bray, Representative Brown, Representative Dixon, Representative Donahue,
Yes, ma'am.
Representative Fleming, Representative Frazier Gordon, Representative Herron, Representative Huff, Representative Imes,
Here.
Representative Johnson,
Yes, ma'am.
Representative Koenig, Representative Lockett,
Here.
Representative Marzian,
Here.
Representative Miller,
Here.
Representative Reed,
Here.
Representative Roberts,
Here.
Representative Thomas,
Present.
Senator Mills, Representative Meredith.
We do have a quorum and are duly constituted to do business. Being the first interim meeting this summer, we do not have minutes that we need to approve from the last meeting, so we'll get started with the agenda. If the representatives of the Department of Corrections would please come forward, we'll get you all started first. Purpose here was obviously House Bill 211 was filed during the last legislative session. We had an informational hearing near the end of February during the session. At that time, the corrections impact statement was not ready. It got ready, I think, towards the first part of March, somewhere along in there. And so wanted to get your all's testimony with regards to the corrections impact statement on the record as we move forward and possibly talk about this issue again in the future. If you all would please introduce yourselves for the record, and then you may proceed with your testimony. You may want to check your mics and make sure the green lights are on. Try the one over there on the other side, see if it'll work. Hold for just a moment then for technical issues.
Yeah.
Was on, but
Yeah.
Yes.
Check, check.
Mine does. Hello.
We're good over here.
Mm-hmm.
Times work is one of us, yeah.
Yep, we're good.
That work? Like, can you?
Hello.
We waited.
Oh, okay. Okay.
We've been waiting for you.
Senators, we waited for you all. We knew you didn't want to miss any of this riveting presentation. Ladies, if you all would go ahead and reintroduce yourselves for the record so we can capture all that, and then you may proceed.
Okay. My name is Allison Brown, and I'm the Assistant General Counsel for the Department of Corrections.
My name is Amanda Sale. I'm the Director of Offender Information Services with the Department of Corrections.
Okay. Chairman Meredith and members of the committee, thank you for inviting us here this morning and giving us the opportunity to discuss the impact of 2022 House Bill 211. Under the current law, The time spent in custody prior to sentencing is a cost that is incurred by the county that houses the inmate in their jail. Now, under KRS 431.215, that initiates payment by the state for housing a state inmate beginning on the day the inmate is sentenced to incarceration for a felony. Now, under House Bill 211, if a person is convicted of a felony and their sentence for that conviction includes the amount of time they spent in custody prior to conviction, the jail will receive a payment for each day the person spent in custody from the date they were arrested until the date that they were sentenced. Now, time spent in custody prior to sentencing is what is commonly referred to as jail credit. All right, KRS 532.120 mandates that the Department of Corrections apply jail credit to every felony sentence of imprisonment if the defendant spent time in custody prior to sentencing as a result of the charge that culminated in that sentence. So because of the unique wording in House Bill 211, the jails are going to receive payment regardless of whether the defendant is sentenced to incarceration or if they receive probation. And the specific wording that mandates that is the phrase, if the sentence includes time served prior to conviction. Now, the reason for that is per KRS 532.030, there are only 3 authorized sentences for a felony conviction. It's either death, incarceration, or a fine. And the judge determines which sentence is appropriate based on the severity of the crime that they were convicted of. Because of that statute, our courts have held that probation by itself is not a sentence because it does not meet the requirements of that statute. It's not the equivalent of death, incarceration, or a fine. Therefore, even though a defendant may ultimately be released onto probation, he must first be given an underlying sentence of incarceration in order to comply with 532.030. That underlying sentence of incarceration is going to include jail credit that then must be reimbursed to the jail under this bill. So that is why our corrections impact statement included an estimate based on the number of people sentenced to incarceration and the number of people sentenced to probation. Before we get into the cost breakdown for the bill, one thing that I wanted to point out is when we submitted our impact statement in March, whenever it was, we estimated that the annual cost of this bill would be between $112 and $138 million for days spent in custody prior to sentencing. Those amounts were based on the per diem that was in effect at that time, which was $31.34. We put a note in the impact statement that there had been a proposal made to raise the per diem, and if that proposal passed, obviously that would impact our estimated cost. That proposal was in fact passed during the previous session. The per diem has now been increased $4 a day, so it's now $35.34 per day. That in turn raises our estimated annual cost of this bill to $126.9 to $156.4 million. We were able to break that down based on the number of people sentenced to incarceration and the number of people sentenced to probation. So for people sentenced to incarceration, we currently track the number of days of jail credit earned by people sentenced to incarceration. So to estimate the annual expected cost of this bill, we chose to look at the previous 5 years of data that we had. So between 2017 and 2021, there was an average of 2,062,497.4 days of jail credit earned by everyone in the state. If you multiply that by the new per diem of $35.34 per day, that's going to equate to about $72.89 million just for people sentenced to incarceration. For people sentenced to probation, we don't currently have a method that tracks the number of days of jail credit for people sentenced to probation. So we had to come up with an alternative method to calculate for that population. And what we previously provided you was two different estimates. The first one, we looked at that same 5 years worth of data. So for 2017 to 2021, there was an average of 129.4 days of jail credit for people sentenced to incarceration. During that same 5-year period, there was an average of 11,809 people placed on probation each year. So if you multiply that by the new per diem of 34 per day, that will equate to just over 54 million reimbursement costs for people placed on probation. The second estimate we gave you for people on probation was just using data from 2021 as a standalone year. And the reason we chose to do that is because while we were running these estimates, we recognized that the numbers for 2021 were much higher than all of the previous years. So in 2021, there were more individuals placed on probation, but at the same time, we also saw a higher number of average days of jail credit. At this point, we don't know if that is just an anomaly due to COVID, or if that is going to be the current trend going forward. So we wanted to make you all aware of that unique set of data. So in 2021, the number of days spent in custody prior to sentencing increased to 173.5 days. It's about an additional 44 days over the previous years. At the same time, the number of people placed on probation in 2021 increased to 13,615. So an additional almost 2,000 people were placed on probation. So if you use those numbers and multiply it by that per diem of 34 per day, that will equate to 83.48 million for people placed on probation. So our estimate for people placed on probation based on the increase per diem is going to range from 54 million to 83 million additional, plus the cost for the people placed on incarceration, sentenced to incarceration. And so that's how we broke down those estimates that we provided you. And now I'm going to turn it over to Amanda, who is going to discuss the changes that DOC will need to make to implement this bill.
So additional changes for implementation for House Bill 211 will require us to make a change to the Kentucky Offender Management System. That's our system that we house all the inmate and probation information, client information. Changes to that system would allow us to do invoicing for jail credit only. Each offender could potentially have multiple invoices. All of their time is not always spent while earning jail credit in one particular jail. So we'll need to change the process of how we record the jail credit to give probation and parole an option to identify a certain number of days were spent in Jefferson County, a certain number of days were spent in Fayette County. So each jail gets their pay for those individual days. So a change would be required to the Kentucky Offender Management System. The functionality exists currently to process invoices for housing of the state inmates for program completion and program attendance. So that functionality would be very similar. We would just need a separate set of invoices to run for jail credit. Additionally, we would need one offender information specialist position to process the credit process the credit invoices on a monthly basis. That position is a grade 12 with an annual salary starting at just above $31,000. What the process looks like for a monthly basis to provide the invoices and make sure the jails are paid in a timely manner. Each month, invoicing will be ran for all offenders who have jail credit and who have had their sentence calculation officially reviewed and audited. We want to make sure that they're audited. Those days are 100% accurate. So when we implement payments, they're not getting overpayment, but they're also not getting shorted. The way we process the invoices currently for housing and for program completion and attendance, we run 1 month behind. So the plan would be any cases that are audited this month, the jail credit would be invoiced and the jails will receive payment in the following month. And that would continue. A couple of things that we foresee a potential delay in some payments, not all, but some. We continue to have some issues to get the required sentence documents from the courts. Part of this is due to COVID, short-staffed, what have you, but we have to have the documents to ensure the calculations are accurate and then to be able to release the payment. So that could be potentially a delay in some of those payments, but we don't anticipate that to be a large amount.
Right.
I have just a couple of follow-up questions just to make sure I'm clear on a couple of things. For the 21 year, Allison, you gave me the $83.48 million for probation. What was the incarceration number for the 21 year?
So we did not do 2021 as a separate year just for incarceration.
You just did on probation.
Correct.
Okay.
If you want that, we can get that.
Okay,
to
if you can
after
get
this.
that, I think that would be helpful.
Okay.
And then the other question, and this is a somewhat philosophical question, I think. And it may not, this may be more of a question that we need to call the administrative office of the courts in to answer to some degree as well. But when you talk about the probated sentences in this situation, my question would be this. If the decision is made for probated sentences, why would there be a situation where those folks were not looked at for ankle monitoring instead of actually being housed in the jail for that amount of days that they're there, being released on their own recognizance, being released through a bail system, whatever that might be? Can you all speak to that at all, or do we need to go to the court system for that?
Yeah, I can't say for sure what that is. One possibility that comes to mind immediately would be that what they are originally charged with is not necessarily what they're ultimately convicted of. So through plea bargaining, they may be convicted of a sentence that makes them eligible for probation, where maybe the initial charge was not eligible for those types of home incarceration or something. I'm sure there's other possibilities. That's just the first one that I could think of.
All right. Questions from Senator McDaniel?
All right. Well, a little different with this one. Quick question. You mentioned about the employees that it takes to do these things. Are all DOC employees back to working from the office full-time now?
No, they are not. We work 2 days a week in the office and 3 days routinely from home.
And is the contact equally available to folks?
Yes. Absolutely.
And is that decision a workforce decision, or is that a COVID-related decision?
It's a COVID-related decision.
Okay. I will just have to state publicly my disagreement with that. The folks that you guys oversee don't get that option in the county jail system or the state jail system. I think you guys ought to take a hard look at the example that DOC sets for those execution levels of government. Thank you.
Other questions from members of the committee? I would just say that this has been helpful as far as moving forward on House Bill 211. I had requested initial numbers on this in November of last year through staff, got no response or reply from that. We filed the bill in January hoping to get this. We knew that if we were going to talk about it in the House side that we had to do it before the end of February. And so we discussed it in February at a committee meeting here, still never got any response, and finally received the corrections impact statement in March. I think this will allow us to move in a more proper way going forward, and I appreciate having it now and you all being able to be here and talk on this, and you all have made yourself available for further communication as well, so I appreciate that. I do want to give Jim Daly with the Jailers Association a chance to come up. He has had the chance to review this as well, I think, and offer some comments on this with regard to how it affects and impacts them on it as well. Jim, you want to come forward? Introduce yourself for the record and then go right ahead. Jim, check your mic.
That better?
Yep.
Okay. Again, I'm Jim Daly. I'm the Campbell County Jailer and currently the president of the Kentucky Jailers Association. If I might deviate just briefly before I begin my testimony, I'd like to thank each of you for the diligence you paid to local jail facilities throughout the 22 legislative session. Pardon me, with your help, we were able to secure record funding to institute a statewide virtual court system of $15 million, which will ensure that members of the judicial branch who choose to use virtual court will be able to use that with state-of-the-art equipment and make hearings much more seamless. This will also allow future savings to counties by limiting the number of transports from different jails by the sheriff's departments, and will also continue to curb ongoing battle for contraband in our facilities. I'd also like to thank the committee and the members of the General Assembly who voted in favor of the 22-24 biennial budget. This was the first time in over a decade we recognized the need for an increase in daily per diem rates paid for by the state for housing and fully funded the full $4 per day increase. The other thing I would like to say that I noticed particularly is I'd like to thank the legislative branch and the Commonwealth taking our partnership with local jails seriously. I've been involved with our jails since 1997, down here several times during that process, and I will tell you that, and we just had our meeting or our annual training last week, and all the jailers that I talked to were tickled to death with the reception that we received. In the meat of the day, Chairman Meredith invited me here today to further discuss 2022 House Bill 211. This bill should this bill become law, will require the Commonwealth to reimburse counties for an inmate's credit for time served against the state mandatory sentence. Of course, this next part was unfortunately due to the lack of information. I think Corrections has fixed that a little bit today. Obviously, I haven't had a chance to go through that yet, but what I will at my earliest opportunity to make sure that those things track with what information we have and what we've looked at previously. Again, under 532 that they just spoke about, state law mandates that all inmates serving time pre-conviction be given credit for that time. And in fact, they are even given credit for time pre-trial on home incarceration if they are convicted. So what I did was I just took a few minutes to look at it from, and again, I don't have all the numbers throughout the state. Campbell County is pretty enlightening from my perspective. I currently have 118 pretrial felons. When I am at full capacity, in my jail right now, I'm designed to hold 656 inmates. Today, I'm at about 350. If we were at full capacity, as you can imagine, these numbers would be significantly higher. Normally, I'm at 230 to 240 pretrial felons on any given day. Their stays in my facility can range anywhere from a couple of days. The longest that we've had in the short term has been 880 days, so it's a little over 2 years. Campbell County taxpayers are paying for that. Inmate Evans is his name, and we pay for transportation, meals, electric, water, everything that's required to support an inmate in our facility for the entire period of time they're there. Once the trial is complete, Campbell County taxpayers will suffer the loss for that incarceration as long as Corrections doesn't have to pay for that pretrial time. And he will get credit for that time no matter what. I brought some more numbers to maybe make it a little more illuminated. But Shanna Hubers, who the folks from Northern Kentucky will recognize in Corrections because she was in and out a couple of times, she spent a total of 1,827 days in my facility as a pretrial felon. Now, she was there, convicted, it was overturned, she was brought back there for an additional period of time, but the total time as a pretrial was 1,827 days. John Allender, who just left our facility in 21, spent 1,588 days in my jail as a pretrial felon. Emily Sherry, 728 days. Darren Bounds, 936 days. and I can go through a list. I've got 1,322 days on one, 1,200 days on one, 961 days. The list goes on and on and on. So it's a big deal. That's local taxpayer dollars that are being paid to support people that are given credit for that time served. May not sound like a big deal when you hear those numbers they just gave you, but that's local taxpayer dollars that we're not recouping from the state when those inmates are given credit for all of that time served. That's really what I've prepared today. Representative Meredith, if there are any questions, be more than happy to answer those.
Thank you, Jim. I got a question from Senator Wheeler.
Thank you, Mr. Chairman. And first off, I'd like to commend your leadership on this issue. I know at Assembly, and the discussion is very worthwhile and provide a lot of relief on a local level. To what extent is the counties, do they have to actually fund, I guess, the housing costs and everything in an equivalent rate of what the state reimburses for the pretrial detention? Do you know about what cost it is per day on that?
Well, the cost is going to vary by every jail out there.
Sure.
So currently, and understand as a result of COVID and the hiring and the availability of staff right now, our numbers in Northern Kentucky have gone crazy. So I am what routinely or historically would have been about $35 to $40 a day is now $60+ a day to house an inmate. So the cost is nowhere in comparison to what I'm paid at the $36 a day.
Okay.
Starting July 1.
So I guess for the 1,827 day person that you mentioned, then that's an expense to the taxpayer of nearly, what, $30,000? Is that right?
Thereabouts, yes, sir.
Okay, and is that an exceptional case, or is that one that's reasonably typical for a pretrial detention on a felon?
I would tell you, in all honesty, that's an exceptional case. But it's not unusual for me to have them for months or several of them for well over a year.
Okay, might be permitted a brief follow-up. What would you think the average for detention length for a pretrial felon? And I understand it probably varies by county and circuit, but what would you think that the average pre-felony detention is statewide?
I apologize. I would have no idea. I don't have a way to track those numbers.
What about in your particular county?
My particular county, I would tell you, and again, I'm going by memory because I looked this up last week, it's about 173.
Okay. Thank you, Mr. Chairman.
Representative Johnson.
Thank you, Mr. Chairman, and thank you for all three of you for the presentations that you've provided today. I have recently discussed this issue with my jailer in Davis County and also the judge executive, and it's becoming an increasingly problematic situation for them. For example, I just wanted to put on record that at Davis County, even with the increased reimbursement rates we're looking at a $3.3 million shortfall that Davis County residents are having to pick up the tab for with this situation. So, Mr. Chairman, I appreciate your leadership on this and look forward to, in the next session, when we deal with this issue. It's just going to get worse if we don't do something with it. And again, thank you for your presentations.
Thank you.
Representative Bray.
Thank you, Mr. Chairman. So going through some of the pretrial lengths that, you were talking about 1,200 days, 900 days, I understand that those are extenuating circumstances and probably aren't on the average. In those cases, what's causing, to your knowledge, what's causing such a delay? Anytime you're going over, let's say, a year for, the pretrial portion of this, I fail to understand. I mean, obviously, it's a court issue of some kind, but can you speak to that?
I can, from what my limited knowledge is for Campbell County. Some of those long ones I talked about were either really serious charges. The Shayna Huber is the one that shot her boyfriend in Highland Heights, Kentucky. Again, she was there and then back She got her sentence overturned and came back. So hers was a couple of 600-day periods, right? The other ones, it could be, a lot of it is a result of defense strategies, or I would think Ms. Snodgrass would tell you that staffing for her, she has the same staffing problems that a lot of Commonwealth attorneys do as far as getting prosecutors. I went from having a couple of circuit judges to only having 2 in Campbell County now, in a family court. So it's a myriad of issues in our court systems, but a lot of it's defense counsel, and a lot of it's just timing on getting people in and out of trial.
Thank you.
Any other questions from members of the committee at this time? I would just like to say, following up again, I appreciate all of you all for coming, and I think it will behoove us at a later time to probably bring AOC in to talk about this a little bit further from their perspective as well. And I think anybody that knows me on this committee or throughout my time in the General Assembly knows that I am not somebody who believes in letting the good get in the way of perfect. I think this is a building block that we can work off of to maybe hone a better bill, maybe deal with the issue that you all have brought up with regard to probation and how that affects. And then with Jim's comments, also be able to maybe look at some time frame to lower that actual dollar amount for these outliers when it's over a year. I mean, when it's a year that's being credited, that's a significant cost to the county that the state is not offsetting and should be a state cost at that point, frankly. So I think there's a lot of things that we can look at going forward. Obviously, we need to talk to AOC about some of these sentencing issues that we brought up with and holding people prior to conviction that are going to end up getting probated, why that process has happened, and other things. So I appreciate you all being here and presenting on this today. I also want to recognize my friend, Big Josh Lindbergh. This time I would ask Representative Timoney and his group to come forward, the Lexington Citizens Group. When you all get seated, if you would, introduce yourselves for the record, and then you may proceed with your testimony.
Thank you, Chairman, and thank you, committee. It's always a pleasure speaking during the interim, and I especially enjoy speaking at committee meetings where we get Representative Bray up before noon. So I know that his interim hours are quite a bit different than the rest of ours. I don't even know if those count as banker's hours, but no offense.
You might be out of order, Representative.
First off, my name is Killian Timoney, State Representative, 45th District, Southwest Lexington. I'm going to go ahead and give my guests an opportunity to introduce themselves and kind of give some context as to why we're here.
I'm Patty Broadbent, a Lexington resident.
Diane Atchison, Lexington resident.
And I am David Kloiber. I'm the council member for the 6th District for the Lexington Fayette Urban County Government. And we're here today because there's been some issues in Fayette County dealing with utilities and tree clearing, and we have a presentation that I think Diane's putting together right now to start up.
How do I make it cover the whole screen? Just